How to win in the Arkansas Small Claims Court coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. So grateful to have you. I'm Jordan Farkas. And for those who have subscribed between the last video and this video, thank you very much for doing that. It is very much appreciated. If you haven't yet subscribed, please take a second to hit that subscribe button and the notification bell so you don't miss a future video. If you wanted to learn more about me, if this is your first time coming to my channel, then you can see a brief bio video on the homepage of my YouTube channel. Generally, if you have any questions or comments, you're always welcome to leave that in the description below. This video is with respect to talking about how to win in the Arkansas Small Claims Court. That said, if you have a general question about succeeding in small claims court, you're welcome to leave that in the description, and I will do my best to respond. I can't give specific legal advice, but I can certainly talk in generalities based on my experience as a retired small claims court attorney. And while this channel is relatively new in its infancy, it's February 2025 as I record this, there's a much better chance that you will have your question addressed versus as the channel continues to grow, it may be a little bit more difficult to get to everyone's comments and questions, though I will always do my best because the point of this channel is to help you win in small claims court. And a great way to do that is by addressing questions that you, my audience, have. So without further ado, once again, this video is about winning in the Arkansas Small Claims Court. It's part of a new video series that I launched to talk about the small claims courts in states across the United States of America. And I did skip out on Alabama because the websites giving information about that court in particular are down as of the date of this recording. I do hope to circle back to do a video on the Alabama Small Claims Court, but for now, I've done one on the Alaska Small Claims Court and more recently the Arizona Small Claims Court, and now we're up to the Arkansas Small Claims Court. So let's jump in. For those who have watched my previous videos, you will know that I am old school. I use my trusty whiteboard over here that's getting a little scratchier and dirtier with time. I may have to replace the whiteboard, but for now we're going to use this. I like to have a visual aid up. It makes it a little bit more interesting than just staring at my face the whole time. And also bear in mind that although this is specific to Arkansas, and I mentioned this in my other videos on the other small claims courts, being Arizona and Alaska, I try and throw in general tips and guidance that can apply no matter which small claims court you find yourself in or potentially in. Okay, so even if you're not in Arkansas as you're watching this, there is still a lot to learn. Also, there's a lot of overlap between small claims courts across America. Of course, there's a lot of differences too, and that's why I'm doing videos on the various courts around the world, starting with the United States. So jumping right in here to my whiteboard, on the left side here in blue are kind of general tips and guidance, and the red over here to the far side, I deal with the more specifics regarding the forms you have to serve and provide to the defendant, your timelines, etc., etc. Okay, so the first thing I jotted down here is what is the monetary limit of the Arkansas Small Claims Court, and the limit is for claims up to $5,000. By the way, there are excellent resources up online that I'm going to link you to in the description below. There's a website of the Attorney General of Arkansas that goes through a lot of different information and guidance for small claims court in Arkansas. It's wonderful, actually. It was a great resource for me, so I'm going to link to that. And there's also a link, that website actually links to another site that I'm going to link you to directly that actually has sample forms that you're going to need for the Arkansas Small Claims Court, as well as guidance and tips and strategies as well. Not legal advice, but definitely strategies. But in any event, the Arkansas Small Claims Court monetary limit is for claims up to $5,000. Attorneys are not allowed in the Arkansas Small Claims Court, so you must be self-represented. If it is determined that you have an attorney or you want to get an attorney and you make that request to have the matter transferred, then the matter will be transferred to the higher court, to the district court, where attorneys, I should say, are allowed. But in the small claims court, attorneys are not allowed. Another instance, by the way, where the matter may be transferred is if, let's say, you as a plaintiff file a claim for up to $5,000, but the defendant files a claim back against you known as a counterclaim for more than $5,000, then the matter will be transferred to the district court. All the information I'm sharing with you, once again, is not legal advice, but based on information that I've gathered and am condensing for you here in this video, which I gathered from the small claims, from the various websites, I should say, of both the Attorney General of Arkansas and the other website, I'm forgetting the name of it, where it was linked from that website. Now, it's interesting to note, I saw here that the statute, I've talked about statute of limitations in earlier videos where I talk about small claims court tips. Generally, a statute of limitations means that you have a time limit in which to file your claim. You can't just file a claim anytime you want for the rest of your life. People are entitled to finality. Also, memories get faded with time. So in every court, in every jurisdiction, there's a different statute of limitations that calls for when you are allowed, or up until when you are allowed to file your claim. So if your dispute is over a written contract, then I've put over here, then the limitation period you have is 5 years from the date that that contract was breached. Of course, it's open to interpretation when a contract is considered breached. I'm not going to go down that rabbit hole here, but never take a chance and wait to the last moment, because things can be disputed as to when the breach actually occurred. Okay, so for example, let's say there was an initial breach by the defendant to do some work in your garden, and the defendant did some work but then didn't do the rest of the work. So one may say that the limitation period starts from the initial breach. Somebody else may say that it starts from the later breach. So don't get into all that. It's best to go with the earliest possible date that the limitation period can run from, and therefore you are safer in filing your claim within the statute of limitations time period allowed. That said, of course, you may be watching this when you're not sure if you're still within your 5 years. So it's worth consulting. Attorneys are not allowed in court, but you may want to consult, hopefully get a free consultation with an Arkansas attorney who may be able to better guide you, because although the rules of procedure are more relaxed in small claims court, I did note down, I'm actually jumping, but once it's coming up, there are rules of evidence, as I've noted down over here, and rules of civil procedure. By the way, I know my handwriting is very messy. I don't expect you to be able to read this in the video. Maybe you can if you've got really good eyesight, but it's more as a guide for me to be able to show you as a visual on my whiteboard, and again, to keep it a little more interesting than just looking at my face. But don't worry if you can't read all the words. I'm speaking everything out loud. Also, you may not be watching as you are on my channel. You may be doing other work, listening to this in the background. So don't worry about actually having to see the whiteboard. I'm trying to speak it all out. In any case, there are various rules of civil procedure and rules of evidence. And of course, there could be case law and all sorts of other decisions made in the past that deal with the issue of the limitation period. So don't despair if you think you've already missed the 5-year period. It's possible that you haven't. And just to round out that discussion, for oral agreements or oral contracts, the statute of limitations is actually less time. You've got 3 years from the date of the breach. How you determine when there was a breach when it comes to an oral contract or an oral agreement, again, I'm not specializing in Arkansas law, so that may be a question for a lawyer in that jurisdiction. But generally speaking, just know that that's the limitation period for oral contracts. Now, in terms of jurisdiction, where do you file your claim? So as usual, this seems to be a common theme. You should be filing it in the jurisdiction where the defendant resides, but it does state that you can also file your claim in the jurisdiction where the defendant was supposed to have done work. Now, bear in mind, it may be easier to file in that jurisdiction where the defendant was supposed to have done work or performed the contract, i.e., let's say the defendant was supposed to do landscaping services for you. Okay, even if the defendant resides in a different jurisdiction, it may be easier for you to file where you live because that's where you live. But bear in mind, if you get judgment and then it comes down to collecting on your judgment and maybe enforcing on that by way of a writ of execution, which I'll talk about soon, and I've talked about that in earlier videos, where essentially you're trying to put a lien on the property of the defendant, you have to check with the court whether or not you can still proceed to file a lien in a different jurisdiction from where you got the judgment of the Arkansas Small Claims Court. Now, it can be that if you file anywhere in Arkansas, that can be enforced across Arkansas. I'm not sure because I'm not from Arkansas. Again, that may be a good question for an attorney that is actually residing and practicing in Arkansas. So just be mindful of that. It's a good question that you can ask an attorney. That's another part of these videos, by the way, is to enable you and to empower you to know what sort of questions you may want to ask if you do decide to consult with an attorney in your jurisdiction. Where I can help is giving you my experience and general tips and hacks and strategies, because I practice in small claims court exclusively for so many years. But if you wanted to get more into the nitty gritty of the specific laws of your jurisdiction, it may be wise to consult with an attorney in your jurisdiction. Okay, but anyway, that's something to bear in mind in terms of jurisdiction where your small claims court case is begun. And some other notes that I noted down here before I switch into the procedure is that, as I've mentioned in other videos, there is the mechanism of subpoena. Subpoena is when you have a witness that you want to have at court and you can't be certain that that witness is going to attend. So it may be advisable to prepare a subpoena form and serve that on the witness, rather, to make sure that that witness attends. Again, bear in mind strategically, if this witness is somewhat hostile to you such that you have to file a subpoena, it may not be the best witness to rely upon. But there are circumstances where it makes sense to do that, if nothing more, to show the judge that if the witness does not attend court, at least you can show the judge that you did everything legally possible to ensure that the witness is there, so that your case is not prejudiced for the witness not being there. What can the judge do? Well, the judge can maybe adjourn the trial or provide a continuance, as it's known, so that the witness may be served another time, or maybe there's some sort of contempt proceedings that may be involved when it comes to a non-attending witness under a subpoena. Again, that's getting into the weeds and beyond the scope of this video, but just know that there is a mechanism for securing witnesses by a subpoena. Of course, if it's a friendly witness and you can count on them to appear in court, it may not be necessary, but otherwise, subpoena is a mechanism as well. And I mentioned the idea of continuance, just jumping in my list here because I mentioned it already. So a continuance is, let's say there's a trial date set, but you cannot make it. So you can make a request in writing to the judge in advance, setting out why it is you can't make it to the trial date that's been scheduled, asking the judge for a continuance to reschedule the trial for a date that you can be in attendance. So don't fret if a trial date was scheduled for something that you cannot make because of something else on your calendar. You can ask for that continuance to ask the judge to reschedule the trial date. And going back on my list, this was so very interesting to me because it says right on the website to come to court prepared. Now, what does it say about preparation? There's a whole bunch of things. It talks about having a timeline of events prepared, being courteous, not arguing with the other side, speaking only to the judge, not being disrespectful, dressing appropriately for the occasion. These are all different tips and strategies that I shared with you, my audience, in earlier videos. So I feel somewhat validated, not that I need that validation, because if I shared it, it's coming from my experience, but it's interesting to see that written right onto the Attorney General of Arkansas's website. So it goes to show you how important it is. It's not just me saying it, it's the Attorney General of Arkansas saying it as well. Of course, in my videos, I get more into detail about that with various stories and examples of why these things are important. But just know that in Arkansas as well, the court goes out of its way to specify, to stress that you should come very prepared. Preparation makes it that much more likely that you're going to succeed in court. And again, that's the goal of my channel, to help you win in small claims court. And how do you do that? By coming prepared. And how do you come prepared? Well, one of the ways is watching videos like these so that you know what to expect, you know what questions to ask, and you know how to prepare yourself. And again, if you're just landing on this video, you haven't seen my other videos, go to my library. I've got general tips and strategies of winning in small claims court that aren't specific to obviously Arkansas or any other specific courts. They're more general for courts around the world. Now, just a few other notes that I have down over here. Actually, I covered this already about going to district court if it's more than 5,000 or if there's attorneys. And I've talked about the rules. So I've covered some general ideas about the Arkansas Small Claims Court in blue here. Now to go on to the specifics of the forms and what the procedure is. So in Arkansas, it starts with a complaint form, and you have to fill out that complaint form, which has the defendant's name and address and details of what happened, a brief description of events, and you provide a copy of that complaint form along with a form called the notice to defendant and the answer form. The answer form is the form that the defendant has to fill out and file with the court. The defendant has, as I wrote here, 30 days to file that answer. The website does state that there are cases where defendants will not file an answer and still there will be a trial date set. So I'm not sure how that works. I think in most cases, the defendant should be filing that answer within the 30 days. And as I've mentioned in earlier videos, you do have to prove that you serve the defendant, and that's done with the notice to defendant. So after you serve the defendant with these forms, you file the notice of defendant, which sets out how and when you serve the defendant, and that allows the court to determine when the time begins to run for the defendant to file their response. Now, if the defendant once again, the defendant can counterclaim against you. If the counterclaim is for more than 5,000, the matter will be transferred to the district court. If it's for under 5,000, then it will remain in small claims court, and both your claim and the defendant's counterclaim will be heard together at the one trial for both claims. If the defendant fails to defend or doesn't show up, then you can ask for default. I've talked about default in earlier videos that I've done for you here, which means that default is when there's no defense to your claim. So in such case, you can ask the court for judgment in absence of the defendant, that's known as default. If the defendant does file the answer, then you will have the trial date scheduled. And at the trial, as I talked about before, you should come prepared, have a timeline ready. See my earlier videos for much more on how to be prepared for trial, how to ask questions, opening statements, preparing a book of evidence, etc. Now, after the trial, the judge will make a decision, and that will be the judgment. And after the judgment, there is allowance for an appeal within 30 days of the judgment being entered into the court docket. One has 30 days to appeal. Now, if let's say there's a judgment against you and you're the one appealing, you may have to post a bond to secure the finding of the appeal, because if the appeal goes against you, the court wants to know that the other party has a right to get that judgment amount afterwards. So bear that in mind. You may have to post that bond in order to cover what may be the judgment against you in order to file that appeal. And of course, once you get into appeals, you start talking about attorneys, and that can cost a significant amount of money. So take it with a grain of salt that yes, appeals are allowed, but that doesn't always mean they're cost effective. I've said many times, I don't know if I've said it on this channel yet, but don't do things out of the principle necessarily. I'm not saying you should give up on your rights. I believe in justice, but sometimes the best decision is the smart one for you, even if it means you have to walk away from something. Again, I'm not encouraging you to walk away necessarily, but for example, let's say somebody wronged you for $20. Are you going to go through all these steps and all the time-consuming forms and procedure and stress and headaches, etc., for the $20? Again, that's a personal decision. If you want to do that, this channel is also for you. I want everybody to be able to win in small claims court, anybody that has a legitimate claim. And again, I'm speaking from a plaintiff's perspective. The intention is to do videos from a defense perspective as well. And of course, justice goes both ways. Somebody who's been wrongly sued has a right to vigorously defend against their lawsuit. In fact, they don't really have a choice. The plaintiff is the one who has the choice to file the claim. The defendant is the one who has no choice but to respond. But in any case, sometimes you have to use sound judgment. So if you lost a case and you really believe strongly, but the entire case was for $20, you may not want to start getting into appealing. Also, the filing fees are usually more than that. There are waivers, by the way, if you check the websites. So far, the small claims court websites that I've seen, I believe it was also in Arizona as well as Alaska, and it's probably in every court. There are procedures in place where you can ask for a waiver of fees depending on income and all sorts of other means. But generally, there are filing fees to pay. So for a $20 claim, the filing fee will probably be more than your actual claim. In any case, that's a bit of a digression. So now with getting off of appeals, so let's say there's a judgment, but let's say the defendant doesn't pay. So remember, judgment is only worth the piece of paper it's written on until you could actually get money out of it. It's not up to the court to get that money for you. You have to do it. Of course, the court aids with various forms and mechanisms, but you have to take the steps. So the two steps that are in place are garnishment. Okay, a garnishment means anybody who owes money or has money for the person who is the judgment debtor, the one who owes you the money, you can seek that they pay you instead of giving that money to the defendant. So a common example will be where the defendant, the judgment debtor, the one who owes the money, where the judgment debtor works. So you can garnish up to 25% of the disposable income of the judgment debtor. Now, how that's determined, I'm assuming that's up to the employer to demonstrate. The employer who's served with a garnishment will have to demonstrate that in the garnishment for how much money they are providing under the garnishment. But in any case, that's the amount. There's also the idea of garnishing a bank account of the judgment debtor. I did note over here that they have up to 10 days to file their response to any garnishment request. And if they don't, you can actually get a judgment based on what I read from the actual bank or employer themselves. So it's very important if you happen to have come across this video and you were actually served with a garnishment under a small claims court judgment, bear in mind that you may have a very strict time deadline in which to respond to a garnishment. So don't take it lightly. And the court does take pains to point out as well that it's up to you to follow up with the court. Okay, don't expect that the court is necessarily going to notify you. In some small claims courts, they will. Oftentimes, though, that could get lost by mail or whatever the case is. So make sure to follow up with the court to see if there's been any changes in status. That doesn't only apply to garnishment, that applies across the board. Whenever you have a small claims court case, always make sure that you're keeping on top of things. If you haven't gotten a notice of any trial or any hearing, there may be one coming up that you're unaware of. So always be on top of keeping up with the court staff in order to determine, what the next steps are of your small claims court procedure. Oh, by the way, I forgot to mention, I'm going a bit out of order, but I forgot to mention also in terms of serving the defendant, the ways to do that are with the sheriff or with somebody authorized to perform service under civil law, such as a process server, or it can be done by certified post as well. I don't even know if I put this on my whiteboard, but I definitely had that on my notes before preparing. And finally, the last thing I've noted down here as the other method of enforcing your judgment. Sorry, I went out of order there. So we talked about garnishment. The other method is writ of execution. So let's say the defendant has a property and you want to kind of put a lien on that in order to secure that you will get paid before the defendant or the judgment debtor has the ability to pay out, to sell that property rather. You can prepare the form of a writ of execution and ask that the sheriff take care of that writ. There's all sorts of procedural steps. You can check out the websites to learn more about that. You may have to post a bond in order to cover any sort of mistakes that may be made in the process. So see the websites that I'm going to post in the description to learn more about that. So that concludes our discussion of how to win in the Arkansas Small Claims Court. I hope you found that helpful. If you feel that I may have missed something, or if there's important information, maybe you're in Arkansas, maybe you have experience at the Arkansas Small Claims Court. If you feel that I've missed anything that's important or maybe made any mistakes, then feel free to leave that in the description below. I will do my best to address that. If you have any general comments or questions, as I've mentioned, whether it's regarding Arkansas Small Claims Court or in general, feel free to leave that in the description as well. If you know anybody who can benefit from this, feel free to share this video, pay it forward, as they say. Don't forget to like the video, hit the subscribe button and the notification bell. It takes a second, definitely will help you not miss a future video, and also helps me to continue to produce videos just like this one. And until next time, thank you once again for visiting, and I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.